Yes, I need your email to send your offer and everything to her. Okay.
Who was supposed to be in post one? Oh, they haven't said anyone there yet?
Oh, yeah, you're.
Oh.
Uh-huh.
I said I'm marking.
In post one? That's
Post
the
one is Gregory.
jailer. Oh, you go. It's supposed to be. Supposed to be who?
Ribenen.
Oh, okay. Which one is Malik Blocker?
Malik Blocker, they have him in post two. Post two is four.
What's your name in the jail?
And have you gotten discovered yet? You have, okay.
What's your name in the jail? Now, I see Mr. Haptel and there's another person in the jail. Okay, on the record, in the matter of the people of the state of Michigan versus Gatuma Haptalim, file number 24-01426, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of the defendant, who's present by way of video conferencing this morning from the County Jail.
Okay, thank you. Today was the date and time that was set for a probable cause conference. The matter is scheduled for a preliminary examination, May 31st at 1:30. Are we continuing to examine this?
I believe we are, Your Honor.
Okay, was there an offer?
There was, Your Honor, the offer at this time, and Mr. Feigelson and I are in some ongoing negotiations, but the current offer is for Mr. Habjalon to plead guilty to an amended count 1 of home invasion 3rd degree and pay restitution. And we would dismiss the remaining counts in the habitual offender notice.
Okay. Okay, I'm currently scheduled for another examination that's gonna take up the time for next week, May 31st. So because of that, I have to go beyond the 21-day timeline. Mr. Haptalim, you have the right to have a preliminary examination within 21 days of the date that you're arraigned unless you waive that timeline or the court finds good cause to go beyond that 21 days. And so I am finding good cause to go beyond that so that I can reset your matter for a new date, okay? Can you hear me?
I hear you. I'm not sure how to respond to that.
Oh, do you have a question about it?
So it's going over the 21 days because of what?
Because the court has another co-defendant, 9 co-defendant exams scheduled in that time slot already. So we won't be available for me to hold your exam. So I have to find good cause to adjourn it.
Okay. Does that mean I'm waiving that?
No, you're not waiving that. I found good cause.
Okay, all right.
August 9th at 8:30. New date is August 9th at 9:30. I'm sorry, at 8:30.
Okay.
Okay. Any additional matters for today's record, Mr. Feigelson?
Nothing on behalf of the defendant, Your Honor.
Nothing for the people, Your Honor.
Thank you, counsel. You're all set, Mr. Haptalim. Okay, they're supposed to put blocker on as well. Oh, I thought he said his last name was something else. Sir, what is your name again?
Malik Blocker.
Okay, on the record in the matter of the people of the state of Michigan versus Malik Blocker, file number 24-01407. And I also have 24-00655, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Malik Blocker today.
Okay, Mr. Blocker, I have in file number ending in 1407. Today was the date set for probable cause conference on a home invasion, assault with a deadly weapon, a felony firearm, unlawful imprisonment, aggravated stalking, domestic violence, and there's 3 felony firearms actually. And then I also have in file number ending in 655. Today's the probable cause conference for unlawful imprisonment, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 3, domestic violence, aggravated second offense notice. And there's a count 4, assault with a dangerous weapon and a habitual offender 4th offense notice. And then I have a bond violation on that file. And I'm inclined to believe the bond violation is that he picked up the case or had contact with the alleged victim. Let's see. Same victim in both files.
May I be, sorry, Your Honor, may I be put out in a breakout?
Not while I'm talking.
Okay.
Okay, so there is a bond violation here that I'm gonna arraign you on. The allegations is that you violated the terms and conditions of your bond on file number 24-01407 by having contact through third party with a Kiara Rich in violation of your bond condition. There's a police report attached that would support the allegation of that bond violation. And so you have the right to have a contested hearing. You have the right to be represented by your attorney at that hearing. If you're found to be in violation of your bond conditions, your bond can be revoked. You can be sentenced to 93 days in jail for contempt of court and or $7,500 in fines. Do you understand that?
Yes, Your Honor.
We'll enter a plea of not guilty at this time. We'll set it for hearing.
Not guilty, Your Honor.
Okay, that we've entered a plea of not guilty on the violation. It'll be set for hearing the same date as your exam. You're currently scheduled in both files to have a preliminary examination on May 31st at 1:30 p.m. However, the court has another matter that will be proceeding at that time that will take up the entire day. So we have to find good cause to go beyond the 21 days so I can reset that. So you do have the right to have a preliminary examination within 21 days of the date that you're arraigned. And that right is yours unless you waive it or the court finds good cause to go beyond the 21 days. So for the reasons that I just stated, I'm going to find good cause to adjourn your matter beyond 21 days, okay?
Yeah.
August 9th at 9. August 9th at 9 a.m. for both.
All right, thank you, Your Honor.
Any additional matters for today's record?
Nothing for the people.
Nothing on behalf of Mr. Blocker. Ms. Petrowski, is this your matter file or Mr. Pfeiffer's file on the 9th of August?
So it's marked as Mr. Pfeiffer's file, but I haven't been able to get in touch with him about he's obviously not here this morning, so I was just handling the matter on the record. I'm anticipating it's going to be his file moving forward, but he and I are going to talk and we'll make sure that you are in communication with the right attorney.
Good enough for me, thank you.
Do you want to break out room with your client?
I do briefly, Your Honor, please.
Who's in the jail?
Jacob Garcia.
Jacob Garcia is in 1. Who's in post 1? This one looks like it could be frozen, but I could be wrong. Can you hear me in post 1?
That should be Gregory.
Post 1 is frozen, so, okay. What's your name, sir?
Right.
What's your full name?
Greg Rabinin.
Thank you. Does he have an attorney?
He does, his attorney is Sarah Donnelly.
Rabinin is?
Yes.
Okay. I don't see that in the, we don't have an appearance for Garcia. Okay, let's see, Mr. Austin, which man are you here for, Shaw?
Yes, Your Honor, at 9 o'clock, he told me he should be zooming in for that.
Okay, he's not zoomed in yet.
I just wanted to let the court know where I was, what was going on. I have one with PCC to handle with Judge Ward.
Okay, sounds good, thank you. Rob Holberg,
That's a victim on the Whitney Rice case.
is there a reason why he's in my son?
There isn't, we didn't tell me need to be here today.
Mr. Holberg, can you hear me? Did they put Rice on?
No, she was in person.
Oh, she's downstairs. Okay, well, I'm going to, she's not responding, so it's being removed from my.
Understood.
I'm not seeing Mr. Freeman or Deaton, Joshua Deaton.
I saw Freeman earlier, but I'm not sure where he's at now.
Okay, well, I'm Victoria and his client. That was at 8:30. Okay, let's see. I see Samuel's peek in, but I don't know what's going on with his case. Samuel's is on Herrick and Rice.
Yes.
Okay, well, those are at 8:30, so we need him to.
Yeah, Mr. Deaton was here. He checked in.
I don't see him in the courtroom or his attorney. They have to be brought up. Yeah, but I don't see Mr. Samuels here.
See either one of them.
Do you see Mr. Samuels out there?
Check the conference room.
Thank you. Morning.
Good morning.
No, because I can't find any defense attorneys. For some reason, they think they should go to all the other courtrooms before they come here. So I'm gonna start bench warning their client, their.
Yes, I know.
Yeah, let's see here. Mr. Holberg,
Yes, Your Honor.
why are you in my virtual courtroom?
I was trying to view the probable cause hearing for Whitney Rice.
Okay, you can view it on YouTube unless you were subpoenaed to be in the courtroom virtually. You cannot be on the virtual courtroom.
Okay, I just got a subpoena from, sorry, that's for the 31st. Okay,
Correct, and that date is going to be changed because we have another matter going on the 31st. But we don't know what that date's gonna be yet until I call that case. So we're live right now on YouTube. You can just pull up Judge Simmons courtroom on YouTube, okay?
all right, cool, thank you.
Thank you.
Yep.
Okay, let's see. And Mr. Freeman, you have Deaton.
Good morning, Your Honor. I have People versus Deaton.
Okay, on the record, in the matter of the people of the state of Michigan versus Joshua Deaton, file number 24-00431, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of Mr. Deaton, who stands to my left.
Okay, today's the date and time set for probable cause conference for assault with intent to do great bodily harm less than murder or by strangulation, count two, assault and battery. Are we continuing to exam?
Yes, Your Honor, and if I may, the people have extended what I consider to be a generous offer of 1 count of aggravated assault. I discussed that with my client. He has rejected that offer, and we would like to move forward with exam as scheduled, if that would please the court. Thank you.
Okay, we're gonna go on with the exam, but it won't be as scheduled, because it's scheduled for May 31st at 1:30, and I have 9 co-defendant case that's gonna go that week. Okay, so I will have to find good cause to go beyond the 21-day timeline. So for your information, Mr. Deaton, you do have the right to have your preliminary examination within 21 days of the date that you're arraigned. That right is yours unless you waive the 21 days yourself or the court finds good cause to go beyond 21 days. I'm finding good cause because I'll be in a exam for 7 days straight, okay? And so because of that, I'm going to have to reset your matter to a new date and time. Do you have any questions about that?
No, ma'am.
It'll be August 9th and 9th.
August 9th at 9:30 work for you, Mr. Freeman?
Yes, Judge, thank you.
Okay, any additional matters on the record today?
Nothing for the people.
Nothing further, Your Honor. Thank you.
Thank you, you're all set.
Thank you very much.
Mr. Austin was, oh, he's here for Shaw, that's right. Mr. Austin will be right back, Mr. Shaw.
Thank you.
You're welcome. Mr. Yang is supposed to be here on Walls. Walls is present, but hasn't started audio yet. Mr. Feigelson, I think he was off done, unless I missed something. I've not seen Samuels, and I've not seen Samuels. Mr. Johnson, your client's in custody
Yes, Your Honor.
downstairs, or they're gonna put them on poly? Oh, okay. Can we see Mr. Samuels is in another courtroom because he's got people in custody, 3 or 2 matters, 2 people, 3 matters, I think it looks like. Did he go downstairs? I don't know, but we're bringing his client up. I saw him come up and peek in here and then he disappeared again.
Yeah. I'm shooting him an email right now. So.
And then good morning, Ms. Donnelly. Good morning, Ms. Donnelly.
Good morning, Your Honor.
They put both of your people on a little early, so I have both Garcia and Ribbon in here. Did you need to speak to either?
Your Honor, I am good to go with Mr. Garcia. I do believe I need a brief breakout with Mr. Ribanen.
Okay, on the record in the matter of the people of the state of Michigan versus Jacob James Garcia, file number 23-02900, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, James Garcia, who's appearing separately from the Ingham County Jail.
Okay, Mr. Garcia, today's the date and time set for a probable cause conference on a count of domestic violence third offense. The matter is scheduled for exam next week, May 31st at 2 p.m. Let's see. There was an offer extended.
There was, our offer would be for Mr. Garcia to plead to an amended count one of domestic violence second offense.
Okay, counsel, do you want to continue to exam?
Yes, Your Honor.
Okay, so Mr. Garcia, you have the right to have a preliminary examination within 21 days of the date that you're arraigned, unless you waive that 21 days or the court finds good cause to go beyond 21 days. I am scheduled to hold another examination next week that's going to take the entire day. And so because of that, I'm finding good cause to go beyond 21 days and your matter will be reset to another date, okay?
Yes, ma'am.
August 16th. August 16th at 9 a.m. Any additional matters for today's record?
Nothing from the people.
None for defense.
Okay, Mr. Garcia, you're all set.
I am.
You're welcome. Ms. Donnelly, I'll put you in the private meeting with your client. It says 2.3. 2305. Who's in the jail? The gentleman in the jail, what is your name? You don't think that I'm just talking to him? Sir, in jail, can you hear me?
Yes,
What is your name?
my name is Troy Henderson.
Is that the same for Rice?
Broken out into early mid-August.
Your client is here. Are you ready to go? Or you need to speak to him?
No, we should be ready to go on the record, Judge.
On the record in the matter of the people of the state of Michigan versus Matthew James Shaw, file number 24-01459, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing today on behalf of Mr. Shaw. He is appearing with us today via Zoom.
Okay, today was the date and the time that was set for a probable cause conference. I have one count of assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, and count 3 of domestic violence. Are we continuing to examine?
Would be at this time, Your Honor, I've advised Mr. Shaw, my understanding from the court's correspondence is that the court would be adjourning all preliminary hearings for next week if the court's in the middle of a rather lengthy preliminary examination. So I've advised Mr. Shaw of that, but yes, we would ask that the matter continue at this time to the preliminary examination and continue to negotiate.
August 16th. August 16th at 9:30 is the new date, okay? Do you hear that, Mr. Shaw?
Yes, Your Honor, I do. Thank you.
Okay, and just for the record, you do have the right to have your exam within 21 days of the date that you're arraigned. That's your right unless you waive it or the court finds good cause. Because of my schedule on another proceeding, I'm finding good cause to go beyond the 21 days and your matter will be set for that August 16th date, okay?
Yes, ma'am. Thank you.
No problem. Any additional matters for today's record?
No, Your Honor, thank you.
I have nothing additional back from Mr. Shaw. Thank you.
Thank you. You're all set, Mr. Shaw.
Thank you very much.
You're welcome. Whitney Rice is being set to August 16th at 9:30.
Okay.
I'm finding good cause off the record because those were set at 8:30.
Okay.
Same to you.
Oh, okay.
Closing at 8:30. Just trying to see if her. Now might be included. Matthew Samuels is our attorney.
Yeah, so we haven't gone on the record on that case yet.
Beautiful.
Yeah, but yeah, and it's just a probable cause conference, so we're just resetting the date.
I'm aware.
Okay.
Okay, how are you? Hello, Judge, how are you?
I'm well. How are you?
So, and then I'm so sorry. What did you say?
Charles McCain.
Okay, and then and I'm so sorry. How are you support for me?
Yes,
or-
Mr. Terry worked with me for probably about the last 5 or 6 years.
Oh, okay.
So just really excited to see her get a chance to get a life back on track.
Did you all want to step outside for this conversation in front of a judge?
Yeah, we.
Thank you.
Well, yeah.
Well, she knows better. You don't carry on like this in the courtroom. Yeah, well,
Not
you're talking about a defendant that has to come before me. Is that correct?
Yes.
Okay, you need to step outside then. Thank you. Ms. Donnelly, are you ready on ribbon in?
Yes, Your Honor. He's going to waive the preliminary exam and have this bound over.
Okay, we'll have Paige come back in for the waiver. Okay, on the record, in the matter of the people of the state of Michigan versus Gregory Formas Rabbinin, file number is 24-02621, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Gregory Rabbinin, who is appearing separately from the Eagan County Jail.
Okay, Mr. Rabbinin, today was the date and time set for probable cause conference. Your matter is currently scheduled for preliminary examination on May 31st at 1:30. And this is on one count of malicious destruction of a building, 1,000 or more, but less than 20,000. And Ms. Donnelly, how are you proceeding?
It's my understanding that Mr. Rabbinin wants to waive his right to the preliminary exam and have this bound over to the circuit court.
Counsel.
The people would also unconditionally waive the right to preliminary examination and ask the case be bound over.
Okay. Mr. Rabbinin, do you understand that you have the right to have a preliminary examination in this matter here in the district court?
I understand.
You understand that you have the right to require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime, correct?
I understand.
Okay, you wish to unconditionally waive your exam today?
Yes.
Anybody making any promises or threats to you to get you to waive your exam?
No.
Bind over date's gonna be June 5th, 2024. That's the date the circuit court will get the file from the district court. So you do not need to appear in circuit court on that date unless for some reason Ms. Donnelly wants you to be rearranged at the circuit court. She'll file a motion for that, okay?
Understand.
Your next court date will be a pretrial at the circuit court. Ms. Donnelly will be made aware of that. Do you have any questions?
I do not.
I was set at 15,000 cash shorty. That will continue. Any additional matters for the record, counsel?
Nothing from the people.
Your Honor, I did want to address the bond. It is set at 15,000 cash surety. This happened in 2022. So, and he does struggle with housing. He does stay at the city rescue mission, but Your Honor, he has been in custody since he was arraigned on the 14th. So we be considering we're converting it to a PR.
Okay, well, I don't have anything about his criminal history before me. The judge who arraigned him had at least that information.
My understanding, he has no criminal history.
The prosecution want to respond to that motion.
Yes, Your Honor. I also, I agree with Ms. Donnelly that he does not have a prior criminal history. He does have another pending misdemeanor matter. And really the people's biggest concern is just that he does not have a stable address. And so I just have concerns about him being able to be served about future processes and being basically kept track of as his case progresses.
Correct. Does he have a phone number?
Yes, Your Honor, he does have a phone number and an email address. And that other thing he's on bond for is happened at this basically the same time as this in 2022. So yes, we do have a phone number.
What's the phone number?
517-582-3653.
And what he's gonna be at the city rescue mission?
Yes, he would told me that he's been living there off and on for a number of for a significant amount of time. So it's my understanding that there's a good chance that he'll be able to stay there tonight if released.
Due to the age of the case and the fact that this is not an assaultive crime, the court will grant the request to amend this to a personal recognizance bond. Bond is set at 15,000 personal recognizance. All previous bond conditions will continue. Any additional matters for the record?
Nothing for the people.
No, Your Honor, thank you very much.
Thank you. You're all set, sir. Oh, that was Silverthorne's client is on Henderson. I've not seen Mr. Yang. Oh, great. Mr. Johnson's client is in, he's in the jail. Maddie is a female. She is in the jail.
Yes.
We have to call the jail and see if they can put her on.
Put her on or bring her up?
Put her on. She's not downstairs. She's should be at Ingham County Jail. Mr. Rabbit, you're all set. You can let the deputy know.
Understood.
Hey, Paige. I'm covering for Milks on Miss Wright. Do we need to go on the record on that?
I think we'll go on the record just so that, because I believe with the diversion, everything, basically from this point out, it'll be taken out or taken care of like kind of outside of the court. But if we want to leave it set for a P or leave it set for PE date just in case something weird happens, would that be all right? And then I have to talk to diversion, give her information to them, and then everything should be fine after that.
Yeah, I'm good with that as a control date, sure. That way we know. Yeah, I'm good with that.
Okay, cool.
I'll wait till she gets here. I'm not sure. I haven't seen her yet.
Okay.
You can be seated. Mr. Samuels, are you handling walls?
I am not. Mr. Yang had substituted on that yesterday.
You said that
And
you were handling the PCC for him today.
okay, so then if that's, I thought he had arranged for new dates and
I did give him
21, but if
a
you
new
need
date.
me to handle the PCC, I was more than happy to.
You gave him the new date. Is he already? We don't have to go on the record. I can find, I don't know if Mr. Walls is aware of this though. Sign the substitution. On the record, in the matter of the people of the state of Michigan versus Dante Walls, file number 24-01271 FY, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Matthew Samuels filling in for Joseph Yang. I had recently had to withdraw from this case, and Mr. Yang had substituted. I don't know what conversations he's had with Mr. Walls, but it's my understanding that a new date was given and that Mr. Walls will wait his 21 days to send.
Okay, Mr. Walls, did you speak to Mr. Yang?
Yes, I just talked to him like about 15 minutes ago.
Oh, okay. Well, I don't know why he didn't log into the courtroom. Today was the date scheduled for your probable cause conference. You're currently scheduled for a preliminary examination, May 31st at 2 p.m. But the court has a conflict because I'm running a 7-day exam. And so I need to reschedule your matter. I'm finding good cause to go beyond the 21 days to reset your matter, okay?
Okay.
Do you have any questions?
No.
Okay, then you're all set for today.
Okay.
Did you give him a date?
Do you know the new date? Oh, sorry.
Talk to him about it. Okay, what is the date did you give him? It's August 9th. The new date is August 9th at 9 a.m.
Okay, thank you.
You're welcome, sir. Matters was set an hour ago. I found good cause. Maybe
Well,
reset.
we are prepared to. I was talking to my clients downstairs.
An hour?
Yeah, I just came back.
Yeah, we don't set probable cause conferences so that you can take an hour and
I
tie up the other
apologize.
dockets. And now you want me to bring them up?
I'm prepared to proceed now.
Proceed with what?
One's gonna be a plea and one's gonna be a waiver.
Who's gonna do the plea?
Ms. Rice.
We'll have Ms. Rice brought up.
I apologize, Your Honor. Like I said, I've been down talking to them. Took me a while to get in there and there was a lot of commotion, so I mean.
I don't know what the commotion was, but did you go visit them at the jail?
I did. I did not visit them yesterday. I got the offer on Wednesday, so I have not had a chance to speak with them.
I recognize that. Okay, let's see if we can have Rice brought up and then we'll do the waiver later. Or next. And then they're gonna put on Mr. Johnson's client, I believe. Mr. Walls, you're free to go.
Oh, okay, thank you. Bye-bye.
Thank you. Ma'am, are you waiting for a court date?
Yeah,
What's your name?
Shazayla, right?
Judge, I think that might be my case. Is that Shayla Wright, Your Honor? I think that's my case, Your Honor. I'm covering for Mr. Mills.
Rayla Wright?
Yes.
Yes.
Yes, did you need to speak to her?
I believe Mr. Milk spoke with her yesterday, Your Honor, so I don't need to talk to her.
Okay, on the record in the matter of the people of the state of Michigan versus Shaquilla Wright, file number is 22-02337. Ma'am, you can come up. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson standing in for Mr. Milks this morning.
Ms. Wright, today was the date and the time that was set for a probable cause conference. I have one count of embezzlement, agent or trustee, 1,000 or more, but less than 20,000. And the matter is currently scheduled for an exam, May 31st at 2 p.m. Are we continuing to exam?
If I could take this one, Your Honor. The We are currently in the process of getting Ms. Wright re-entered into our office's diversion program. She was previously enrolled in it, and then we were unable to establish an address for her. We now have an address and contact information. So if we could just set it for or reset it for another preliminary examination date, just to keep it on the docket, just in case something weird happens, that would probably be best. But I anticipate that she will have be easily accepted into the diversion program, and then this case will be dismissed.
I'll set it for another probable cause conference. June 21st at 1:30. And so you have the right to have a preliminary examination within 21 days of the date that you're arraigned. The court was going to find good cause just because I don't have a space available on the 31st, which is the original date you're scheduled for an exam. So I'm going to find good cause due to that and to the fact that you're currently expected to go through the county's diversion program, okay?
All right.
Do you have any questions?
No.
We'll get you a copy of your new court date. Any additional matters for the record?
Nothing from the people.
Nothing on behalf of Ms. Wright, Your Honor, today. Thank you.
Thank you. If you can have a seat, we'll get you your next appearance.
Judge, thanks for your time today. Have a nice weekend, everybody.
Same to you. Oh, actually, Ms. Wright, I need you to come back. Did I sign this? I did not. This is Buchanan's?
If the court, they were about to, she run the court.
This was for her to complete a financial statement with who? With the collection? Wait, what is this? I've never seen one of these before in my life. You were supposed to, I guess, complete a.
For collections, they told me they was gonna give me a call for the speeding ticket. I just
Handicap
went on
parking?
Friday, yeah, on Friday. I mean, when I came to court to get my date, I went to collections and they told me they was gonna give me a call and they never gave me a call, but I was gonna go and I
They
looked.
put a note here. It says that you didn't come back to finish paperwork. That's what this note says. There was, this is not before me, it's actually before Judge Buchanan. They prepared a bench warrant, but she had not signed it. So what we'll do is I won't touch this because I have no clue what's going on. I will wait until my court officer comes back and I'll have you escorted back to collections so you can complete this.
All right.
What's your name, ma'am? That's your client. You need to speak to her?
Yes, Your Honor, briefly.
Okay, if you log in, Zoom, I'll put you on in a private meeting room. court, and I'm gonna put you in a private meeting room and your attorney is logging in to meet with you, okay?
Please leave your message for 5-1.
That is correct.
Okay, on the record in the matter of the people of the state of Michigan versus Whitney Rice, I have file numbers 24-01475. And I also have 24-01423, council appointments.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Matthew Samuels on behalf of the defendant, Whitney Rice, who's present and sitting to my right.
How are you, Ms. Rice?
I'm all right. I've been better, but hopefully get back to work and take stuff off.
Today was the date and the time that was scheduled. A probable cause conference on 2 files, and there's also a pending bond violation. And file number ending in 1423. Just so I'm clear, the bond violation is that she allegedly walked into the exclusion zone. Timer must have gone off. Contact the JSG. I have a plea sheet here. It says the people are offering for you to plead guilty in file number 24-01423 to count 2 of domestic violence. There's no objection to sentencing under 769.4A, and then dismiss count 1 in that file and dismiss the counts for file number 24-01475. That's correct.
That's correct, Your Honor.
You want to accept that offer?
Yes, Your Honor.
Okay, you can rise and raise your right hand. You stand up. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can put your hand down. I have an advice of rights and the information sheet. It's 2 pages. Did you read this with your attorney?
Yes, I have.
This is your signature?
Yes, yes.
Okay, you understand the rights here?
Yes, I do.
You want to give up all of those rights today in order to accept the offer?
Yes.
Okay, so you have the right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, I do.
You have the right to require the prosecution prove your guilt in a trial. You have the right to jury trial. You have the right to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness the prosecution intends to call against you. You have the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. And you can waive your right to silence at trial and testify on your own behalf. Do you understand that?
Yes.
And you want to give up all those rights? Yes. Anybody threatening you to get you to give those rights up?
No.
Any promises being made to you in exchange for you pleading guilty?
No.
Are you currently on probation or on parole?
No, I'm not.
You understand that a guilty plea could result in a conviction that you report to a future employer, because I think your current employer is here. Is that correct? Okay, yeah, you have to put this on a future job application. Conviction could also be something that has impact on travel or immigration status that you may be seeking in the future. So you may want to visit Canada for the weekend and they could deny you based on this. You're smiling, but they could do it. Especially in Canada. This, you understand that?
Yes, I do.
Okay, and that, you don't have any concerns about that?
I'm not trying to go there anytime soon.
Well, I've just used them as an example. You could wanna go and move to Great Britain too, and they
I'll
could
stay right
deny.
here.
Okay, okay, sounds good. So that's not a concern for you?
No.
Okay. Are you pleading guilty to count 2 of domestic violence because you believe you're guilty?
Yes.
Okay. As to count 2 of domestic violence, how do you plead?
Guilty.
Tell me what you did to make you guilty of domestic violence.
Probably out of line to the point where I, with my purse in my hand, swat it at my boyfriend and was it the officer? It was just
the boyfriend.
I did swat at him to walk quickly away from me, and I kept swatting him at with my purse to get away from me. And
is his name Robert
it
Holberg?
is, yes, it is.
Okay, was this at West Potter Ave and Stafford Ave?
The Everett School subdivision around there.
Near Everett
Yes.
High School?
Yes.
In the city of Lansing?
Yes.
And that's in Ingham County?
Yes.
Okay, and you used your purse in your hand to swat him away from you? You said yes. I
Yes.
can't hear that. on
Yes,
the- Okay,
it is.
and why were you doing that? Was it self-defense?
No.
Okay, he wasn't approaching you and you didn't feel threatened?
No.
Okay. And he didn't ask you to swat him, did he?
No, he did not.
Okay, and then you all were in a dating relationship?
Yes.
Okay, any additional factual basis?
No, Your Honor, thank you.
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if finding your plea to be made freely, voluntarily and intelligently. I'm dismissing the bond violation because I just not quite understanding what it is anyways. It says that she walked into the exclusion zone and she contacted the police or JSG, and then she was arrested. So it sounds like she was at least trying to make effort to be in compliance with each other, not a meaningful violation as far as I'm concerned. So that will be dismissed.
That is an accurate assessment.
And then the other file will be dismissed. As part of the plea agreement, this matter is going to be set for a sentencing hearing July 25th at 9 o'clock in the morning.
Will that be in person or by Zoom, Your Honor?
She can appear in person or via Zoom. If she appears via Zoom, she needs to have a video. On
what?
phone. Video.
You said that was 9 and 9:30.
9 a.m. And when she's being held on just these matters.
Correct, and the bond violation.
Okay, got it. Denali for those. And then dismiss the bond violation. Her bond, it looks like, was previously 1,000 personal recognizance with a no contact order that was amended.
Okay, absolutely.
That was changed after the alleged bond violation. Did she have an order for evaluation for community mental health? She did. Let's see. She undergoing any ongoing treatment with CMH? Have you ever been engaged with CMH before?
I attempted to, but they said I did not qualify for services when I previously.
Okay. The note that I have here is that they believe you would benefit from some ongoing treatment and maybe an evaluation, so you should look into that, okay?
Absolutely.
Okay, a bond will be amended to 25 up to 10%. Did you post that bond? Will be, okay, bond will be amended to a Personal reconnaissance bond. What's your address?
500 Sprucewood Ave. Lansing.
How long has that been your address?
Since August, well, I closed in the house June 20th, but moved in August 3rd.
Why did you give a different address on the 17th?
Is it on Cedar Street?
You said that your new address was Causeway Bay Hotel.
Yeah, because my home is within the place. I cannot go over to JFG.
Oh, okay, got it. So
So,
it's in the,
I,
got it, makes
yeah,
sense.
I'm trying to stay at the hotel so I don't violate those.
It was in that zone.
My home is the reason there's a tether monitor. I can't go home apparently.
Okay, got it. Does the person live at that house?
My boyfriend lives there apparently.
Okay, so then you
Are
can't.
you?
I'm the only homeowner.
Okay, well, your attorney has to advise you on how to get a resident out of your home, because it has to be a lawful eviction, obviously.
I'm not trying to evict him. We'd like to remain together. This whole thing was a misunderstanding.
That's consistent with my, well, not the misunderstanding of it, but the victim does, from what he's expressed to me, hope that they can kind of get her treatment she needs through this process and then basically kind of move on. So
Is he willing to lift the no contact order to let him move back into her home?
he expressed that he would like the no contact order lifted. It's the people's position that I believe the no contact order should stay in place until after or until sentencing, just so that if she's being evaluated by probation or anything, we could just.
She would have to stay in a hotel then. That's the case. She wouldn't be able to return. And obviously, there's been some level of communication that they want to be with each other.
I can't speak to that communication.
Well, she spoke to it on the record. She said, we want to stay together.
Without speaking.
Yes. I just wanted to just place my concern on the record.
Right,
that's
Mr.
all.
Holberg appeared in the courtroom earlier. He would not start his video. And then I instructed him to go to YouTube, but if he would like to have the no contact order lifted, he needs to appear to the court and request it. Okay, without that, you're not allowed to stay there. So right now, the no contact order will stay in place unless he comes before the court and
Does
requests.
that need to be involved in the hearing, or does he just go to the clerk's office?
Well, he's got to come see me, and then I can remove it. If he can do that today, that'd be great, because the prosecutor's here. But if not, then we'll deal with it next week, I suppose. We're closed on Monday, by the way. And she'll be at Causeway Bay Hotel, I suppose, until the time that a no contact order can be lifted, but it's not lifted at this time. All other no contact orders will continue until it's lifted. Do you understand
Yes,
that?
I do.
That's communication directly and indirectly, not just your residents at Sprucewood. Okay,
Yes.
and then you need to report to probation by Tuesday at 10 o'clock in the morning.
Okay.
Because they need to prepare you for a pre-sentence report interview. They'll give me a update as to whether or not you are eligible for status under 769.4A. I'm also ordering a substance abuse assessment. That's part of your sentencing, okay? Okay, do you have any questions? You know where our probation department is? Building one more down, okay? So no later than Tuesday, 10 o'clock, okay?
Okay.
Phone number.
517-574-1849.
Okay, any additional matters for today's record?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you, you're all set. Rice. Mr. Simmons, you had Herrick?
Yes.
We need Herrick brought up. On the record in the matter of the people, of the state of Michigan versus Maddie Horton, file number 24-01472. Council appearance.
Assistant Prosecutor Kristen on behalf of people.
Good morning, man. Please sound the court. Kareem Johnson, been on behalf of Ms. Horton. Pleasure to see you, Zoom, y'all.
Okay, Ms. Horton, you can hear us, correct?
Correct.
Okay, today's the date and time that was set for a probable cause conference. The matter is currently scheduled for preliminary examination, May 31st at 2 p.m. Are we continuing to exam?
Yes, Your Honor, we are. An offer was made to my client. I explained it off to my client. This time we wish to proceed to preliminary examination.
Okay, and so the court does have a scheduling conflict with May 31st due to another matter that's going before the court. So the court has to find good cause to go beyond the 21-day timeline. So Ms. Horton, for your information, you have the right to have your preliminary examination within 21 days of the date that you're arraigned. However, because I have another matter that's going to take 7 days to get through and it's scheduled for next week, I'm going to find good cause to reset your matter, okay?
August 16th, 9:30.
August 16th at 9:30. That date work for you, Mr. Johnson?
Yes, Your Honor.
Okay. Any additional matters to address today on this record?
Nothing for the people.
Yeah, I'd like to address my client's bond.
How you can do so at this time?
You know, I admit I was not present at the arraignment, so I can't, attest to whether or not the magistrate started with the presumption that Ms. Horton should get a personal bond and work her way up from there in accordance with Michigan's pretrial statute. She is charged with 3 low severity, non-violent felons. The court, because of docket congestion, has just adjourned her preliminary examination to August, over 30 days away. She does live within walking distance of the court. She has indicated to me that she can appear at all subsequent court proceedings by walking. I do not believe that she is a danger to the community. Based on my initial review of the discovery, the reason for the police contact apparently was a car that she was in was shot at. And then accusation rose that she possessed a taser and was in possession of a stolen car. She was the driver of the car, and as far as possession of the taser, the court is going to hear evidence about that at the exam, but I've always found that statute ridiculous. In the state of Michigan, you can possess.
You said as far as what?
As far as possession of the taser, I've always found that statute ridiculous. In the state of Michigan, you can possess a flamethrower, AR-15, and I am a Second Amendment guy. I have weapons, even explosive devices, but a non-deadly weapon such as a taser apparently is illegal. I don't think the court should look at that and determine that she poses any danger to society at large. That's the court to grant her a personal bond.
I was obviously not present during the time she was arraigned. Magistrate Normal Render, there was a bond report provided to the magistrate for her consideration. And so that bond report included a number of matters that she has failed to appear on. So there's a history of failure to appear on more than 3 cases.
Where the report got, what was the date of the last failure to appear?
She failed to appear on June 25th on one, failed to appear on July 24th on another, failed to appear November 14th on another, and then she has another pending contempt bench warrant issued for an aggravated assault. So these are all separate cases that she fails to appear in court on. Bond is only set at 5.2%. It's a low bond, and she's a flight risk.
Sorry, what year was the
2023.
Okay, so almost a year ago.
No, one was November 2023. She failed to appear. But there's 1, 2, 3, 4 cases from 2023 that she failed to appear on. She's not getting a PR bond. Excuse me?
The clients indicated she was in rehab. Failure to superior.
Someone provide me evidence that she was in rehab and we'll address it.
Yes, Your Honor, thank you.
Thank you. Any additional matters for today's record?
Nothing.
No,
for
Your Honor.
people.
Thank you. You're all set for today.
Love you.
Have a good day.
You're all set for today, Ms. Horton.
I don't know. I don't know.
Excuse me?
I don't know what's going on.
You're all set for today. That's what I said. You can let the deputy know that.
Okay. Love you, Shirley.
Thank you. On the record, in the matter of the people of the state of Michigan versus Troy Henderson. And that is in file number 24-01468, council appearance.
Assistant Prosecutor Pete Petrosky on behalf of the people.
Good morning, Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Troy Hunter Henderson, who I see is appearing on screen from the jail.
Thank you. And Mr. Henderson, you can hear us, correct, sir?
Excuse me.
Can you hear me?
Yes, I can hear you now.
Very good. Today's the date that was set for probable cause conference. I have one count of controlled substance possession of methamphetamine or ecstasy. Count 2, motor vehicle unlawful driving away, and there's a habitual offender third offense notice. Matter is currently scheduled for preliminary examination May 31st at 2 p.m. Council, are we proceeding to exam?
Your Honor, I'll address that. I discussed the case with Mr. Henderson in a breakout room immediately prior to this. He will waive the exam and go to circuit court. There, I think, will be an offer that will be placed on the record, but following that, he would like his bond adjust too. And I would advise the court that he's the co-defendant to the previous defendant, Maddie Horton.
Council.
That's correct. And I can place the offer on the record. The offer is for Mr. Henderson to waive up to the circuit court and then at the first pretrial conference plead guilty to an amended count 2 of stolen property, receiving and concealing a motor vehicle with a habitual offender second offense notice, and we would dismiss count 1. The offer would we would dismiss count 1 contingent on him pleading guilty, and then that offer would close at the end of the first pretrial conference in circuit court.
Oh, sounds good. That's complete and accurate, Mr. Silverthorne.
It is, Your Honor.
Oh. Okay, and so the parties are wishing to waive their exam.
That's correct, Your Honor.
Yes, Your Honor.
Thank you. Mr. Henderson, do you understand that you have the right to hold a preliminary examination here in the district court?
Yes.
You have the right require the prosecution to meet their burden, which is to establish that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with the crime. Do you understand that?
Yes.
Do you wish to unconditionally waive your examination?
Yes.
Anybody threatening you to get you to do that?
No.
Any promises being made to you if you waive your exam?
No.
Okay, your bind over date's gonna be June 5th, 2024. You do not need to appear in court though on that date. That's the date the circuit court gets the file from the district court. Your next court date will be a pre-trial. It'll be set after that date. Mr. Silverthorne will be made aware, okay?
Okay.
Silverthorne, you wanted to address bond.
Yes, Your Honor. He also, like the previous, has a relatively low bond at this point. It's 3,010%. He lives at 3216 Jury Street, Lansing. He's on Social Security disability, for which he receives $800 a month. He's unlikely to jeopardize the receipt of that. And while he remains incarcerated, he does not receive that amount. He's married to a Shatia Henderson, who also resides at Jury Street. He's lived in Lansing since 1994. he can post his bond, but he believes his wife is not assisting with him, even though he has the money at his home, and if we're released, could get it, because she is probably understandably upset that he was with, it's alleged that he was with another woman, Miss Horton, at the time of this offense. So it's sort of an unusual set of circumstances. We're not arguing that the bond is set is not pretty low. We're not even arguing that he couldn't make it. He just can't make it without some assistance for getting the money, which is at his home. And so for that reason, this is not a violent offense. The possession of meth was extremely small. And the circumstances for the UDAA appear to have been that he might have been attempting to flee the area, as there had been a reported shooting, as the incident report, if we were to have a hearing, the court would see there had been the back windshield of the vehicle there and had been shot out. So for these reasons, we kind of unique reasons, we'd ask that the court take that bond a little bit lower to a PR bond, or I don't think I've ever heard of this. If he could get a temporary PI bond, he can go home, get his money, and he could post the 3,000 10% bond. But I'll leave it to your court's discretion. Thank you, Your Honor.
Okay, there was a report that the magistrate relied on, indicating he was currently he had a bench warrant for failure to appear in 56A. Was that addressed?
I didn't do the arraignment, and I'm not sure. I believe it was addressed. Magistrate Milmore is very efficient at addressing all of those, and she usually will inquire as to a reason, and then make a decision based on that.
No, I mean, did he get the warrant addressed? Magistrate Milmore can't.
I understand that.
Make sure he sees
that I'm not certain of. That I would address that to Mr. Henderson if he has been in court to address the failure to appear. Mr. Henderson, can you hear everything?
Okay, now what was the question again?
You had a failure to appear when you were arraigned within the last week. This would be at a different court. Have you been taken to that court and addressed that other matter?
Have I been taken to court for that? I haven't paid to appear when I was arraigned last week. I've been in custody since last week.
I understand that.
But you have a matter before 56A. Did you go before 56A?
No, I haven't. I don't understand.
Counsel, did you want to address the motion?
I would leave any alterations to bond to the court's discretion.
Do you know what he's got pending in 56A?
That's the one I don't. I can find it in just a second.
Okay, looks like it's a controlled substance. Yeah, it's got a bond. There needs to be addressed.
I don't know if she remanded him to have it addressed. I have to remand him to have it addressed. I'll amend our bond, but he's got to go see 56A before he can get released. I'll amend our bond to 3,000 personal recognizance. But he's remanded on any remaining bench warrants to have that addressed before he's released from custody. And the court's gonna find. Hold up here, 56. The magistrate didn't put any note in here at all about whether or not that was addressed, and it doesn't sound like your client remembers or is aware that he ever went to another court. That is also for a non-violent offense. It's for a drug-related offense. So he'll get that addressed.
I understand, and I think this assists, but because I think what will happen is that with the court amending the bond to the 3,000 PR, our jail will then inform I think 56A is Eaton or Clinton County will inform them of that, and that county will then have to make a decision to come get him, and he can to address it.
Sounds good. So we'll get that taken care of. But again, all other bond conditions for our file will continue, including his requirement to report to pretrial services within 48 hours of his release, okay?
Thank you, Your Honor.
Do you have any questions, Mr. Henderson?
And so I'm waiting here for another county, you said? That's something I was confused about.
Yeah, yes, you have a warrant, in 56A, which I think is Eaton County. Clinton County. Yeah, you have a warrant in 56A District Court. You need to see them and then they'll address your bond there, okay?
Okay.
But our bond will give you a PR bond. You need to report to pretrial services within 48 hours of your release, okay?
Okay, I understand. Thank you.
Okay, you're all set, sir.
A good day, Your Honor, and have a very good Memorial Day weekend.
Same to you. Is someone back there?
Here.
Okay. On the record, in the matter of the people of the state of Michigan versus Rebecca Herrick, file number 24-01425, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Matthew Samuels on behalf of Ms. Herrick, who is coaching counsel paper right now. Your Honor.
Okay, how are you, Ms. Herrick? I'm well, thank you. Today's the date and time set for a probable cause conference. My understanding is that there's going to be a waiver.
That's also my understanding, Your Honor. People would unconditionally waive their right to the preliminary examination.
And that is true and accurate. There's also going to be an offer placed on the record, and we would like to address bond as well.
Thank you. The offer is for Ms. Herrick to leave up to the circuit court, and then at the first pretrial conference, plead guilty to an amended count 1 of home invasion third degree and pay restitution to the victim. We don't have an exact amount yet, but that is estimated to be between $1,500 and $2,000, and we will have that taken care of before the first pretrial conference. After she pleads guilty, we would dismiss the remaining counts in habitual offender notice, and there's also a sentencing recommendation for a county cap for percent to be served in the county jail.
That's complete and accurate.
It is, except my understanding was that the cap was until the group.
I guess I apologize for that. We didn't discuss this specific language.
I've never heard it where we agreed to a sentencing agreement. We said that we're going to recommend it.
And we can put it on, yes, we can just handle it as a sentencing agreement. Our office has been addressing some of the language that is used when we're trying to discuss sentencing recommendations versus agreements. So I was trying to do it that way. But yes, a sentencing agreement for a county cap.
Okay, how does that differ from what you heard the first time?
Hers was a recommendation. This is the agreement.
Got it.
So with the agreement, that is true and accurate.
Okay, sounds good.
Madam Clerk, Your Honor.
Yes, please. Thank you.
Thank you.
Okay. Okay, so Ms. Eric, you understand your right to have a preliminary examination in the district court. You understand that you have the right to require the prosecutor put forth evidence that will establish if they have probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Do you understand that?
Yes, I do.
You want to waive your exam unconditionally?
Yes, Your Honor.
Anybody threatening you or promising you anything to get you to waive your exam?
No.
Oh. Final date's gonna be June 5th. You don't need to appear in court on June 5th. That's the date that the circuit court will get the file from the district court, okay? Your next court date will be a pre-trial. Your attorney will be made aware of that date, okay? All right, and bond was set up by Judge Ward back on May 11th for 10,000, 10%. I don't have any information other than a affidavit of probable cause. I do not have a prior criminal history, nor do I have a bond recommendation, so you can make your motion and the prosecution will respond.
Thank you, Your Honor. As you can see that these charges have been substantially reduced as part of the plea agreement, which Ms. Herrick is considering taking advantage of, obviously. With that said, Your Honor, I think that the bond was set high based on the higher charges, and would like you to consider what the offer was as to where the facts of the case has led us. With that said, Your Honor, she does have a hold out in Gratiot County on a misdemeanor probation violation. I have been working with Gratiot County to get that resolved, and it sounds like they're just going to use hold. But we need to get her in front of the judge there, and I'm working on that. That should be done soon. I don't think that the R bond is appropriate because I don't know exactly how quick we're going to be able to get into Gratiot and get Gratiot County done. So I would ask for a very low cash bond of maybe $100.
Trust me.
Well, Ms. Herrick does have some of a criminal history. From what I can see, it does not appear to be over assaultive.
She's being charged as fourth defense notice, so she absolutely must have a criminal history.
Oh, yes. I was just, sorry. I was just saying that from what I'm able to see, it does not appear that it is assaultive in nature. So given that she does have the other county cap and that these are fairly serious charges, I would just ask that if she is to be released, or if her bond is to be lowered and she is to be released on bond, that a GPS tether be ordered.
She has failure to appear in the other matter.
Not that that we have in our system or that I can see at all.
What is the hold in Gratiot for?
Probation violation.
I don't know what the
Is
violation
it probation violation because she allegedly picked up a new case?
No, it was before this.
Got it.
But my understanding is that she was about to be released. And whatever happened, I'm not completely up to date with all the facts of it, but my understanding is she was about to be released. And it sounded like she will, once we can get her there.
Bond is amended to 1,010% with GPS tether.
Thank you, Your Honor.
No problem. Any additional matters for today's record?
Nothing for the people.
You're all set. Thank you. And that's all we have except for the discovery stuff, I believe. Is that who you were waiting for, sir?